If you want to be connected with my channel, please press the subscription button and also press the bell icon, and you will get all the notifications of upcoming videos. Friends, today's subject is right to be forgotten. It's a huge and new and very progressive personal right and liberty you can call. And today I'm going to discuss about the starting from dates back 1931 till date. What are the important judgments or rules, and what are the laws in India and abroad in USA and Europe, and whether any individual in India and other part of the world has the right to be forgotten. Say for example, friends, if anybody is implicated in a criminal case or other thing or litigation and other something, and the news has been published in any media, and then the news was spread through search engine in the virtual world, so anybody can get that information on the click of a search. And if it happened that persons, after being implicated in a case, got acquitted from that case, and that person has the right to live in a dignified, convenient, inconvenience free, disturbance free personal life. And if that same historical informations as regards to that person haunts him and stop him and disrupt him from coming and his life to be his or her life to be rehabilitated, so in that perspective he or she might have a right. The right is called the right of being forgotten. So in India, as per the Karnataka High Court judgment, and thereafter there is a proposed bill is coming up. I'll go through these provisions and the judgments and findings in USA, Europe and India. So please watch this video till end. It's a very new concept, because right to be forgotten in the world, when the major informations regarding a person is actually lies and governed by the virtual world, is it at all possible that the right to be forgotten can be exercised in a very strict way, and whether history can be erased, right to be eraser can be used for the historical data, or the history can be rewritten, is the subject matter of today's video. So watch this video, is very interesting topics till the end. Our topic is right to be forgotten. So what is right to be forgotten? So the right of an individual not to be stigmatized for any actions performed or happened in past, so that he or she can lead his or her life in an autonomous and peaceful way. That is now the important right is getting momentum throughout the world, including India. I'll show you the rulings and the latest rules and regulations coming up throughout the world, including India, where the right to be forgotten is getting the approval of judicial thought. And if we go by and see what is right to be forgotten, and right to be forgotten has become very much relevant in respect of the search engine and other online service provider companies, whose duty or whose job is to search someone's details and provide someone. So say for example, someone met with someone been involved or tagged in a criminal case or anything which actually stigmatized him or her, and after he been acquitted or exonerated from that litigations and all, and meantime if something published on media and other, and that was uploaded in the online and in the search engine optimization, that is the result is coming up, and after a long period of time, when the person wants to have a peaceful life and wants to rehabilitate himself or herself in the society, and in that point of time that search engine result against that person's who has already been involved in that case is actually haunting that person's and was disturbing him or his or her to go into the normal life in an autonomous and peaceful, and lead a normal life in an autonomous and peaceful way. So that is the simple conception of right to be forgotten. So everybody has the right to be forgotten, so nobody can detain anyone to be allowed to be forgotten, and when the disqualification attached to something has been removed. So that is a very important phenomena is getting momentum in this virtual world today, and we're going to discuss about in more depth. and we'll see the judgment, rules and regulations and laws prevailing throughout the world. Now, what are the issues related to it? The one of the most important, if you think about that, how this model, how this precious relief or right of an individual can be exercised. And there can always be, say for example, something has been published, something has been published against the persons. He has been involved in a criminal case or charged with a case which is actually stigmatized him or her, and after his or her acquittal, long up thereafter, when he starts his normal life, then he or she will expect that the search engine result or any kind of result in the virtual world will not going to disturb him or her. But in that perspective, if we want to exercise or enforce or we want to exercise or enforce the concept of the right to be forgotten, then there can be some contrary paradigm and contrary thought coming up, and one of them is how these historical data can be rewritten, because something has been published and uploaded in the virtual world, and the search engine has been searching and giving this result for long. So it is part of history. How can this history be rewritten? And there is also there is a question of always the conflict of freedom of expressions. Say when media publish some news when a person is charged with a criminal case, another thing. So in that case, there is a question of freedom of expressions. And if there is any censorship of right to be forgotten, then we have to go back to the history and change what is written in the past. And that actually is not always feasibly viable and practical, and obviously the conflict with freedom of expression and censorship will come. And that also a very famous case in USA, wherein the question of right to be forgotten was not been allowed to override the concept of the first amendment of the constitutions of USA. So I'll come to that point as well, that the freedom of expressions will have an upper hand against this individual right. So Melvin versus Reed in 1931, a lady was charged in a murder case and later exonerated and acquitted from that case, and she started her own private life in a peaceful way. Later on, a film was made on her life, and she which was disturbing her and haunting her and was not allowing her to be forgotten. So she filed a case against the producer of that film, and the court ultimately ordered that she has the right of being protected from the unnecessary attacks on her reputation, etc., depending upon any historical events. So the right of being allowed to be forgotten, the first thing it is any judicial authority give recognitions is we find in Melvin versus Reed 1931 in US. Thereafter, we got a very famous case later in 2015, and that case is actually it's a sharp contrast between the USA law and European law. So before coming to very important thought-changing observations or judgments or ruling coming from the European Court and one from the USA court, and we'll see that the European law and USA law somehow differs in this respect, where in European law the right to be forgotten has obtained a greater recognition than that of the USA, where the if the right of being forgotten is compared with the right to freedom of expression, the freedom of expressions will override the right to be forgotten. We'll get that in Martin versus Hearst Corporations, Second Circuit 2015 case. But in case of European case, there's a Google Spain versus AEPD and Mario Costeja Gonzalez. In this case, we will see that the contrary view was taken by the European court, and herein the right to be forgotten concept got prevalence over the other issue. So I'll discuss both of the cases in detail. In Google Spain versus AEPD and the Mario Costeja Gonzalez, we see that this is one of the case where this this Costeja Gonzalez name came up in a litigation, and his property was also been published, and that publications went through the uploaded and went through the and it was available in the Google searching and all other. And when the matter has been settled up, and he was exonerated from this liability and all this, he filed a case against the Google, and paying for that, both against the primarily he filed a case against the media company who published the news, and also against the Google being the search engine, wherein if anybody search on that name, he'll get those historical data, which is actually not allowing him to enjoy the right of being forgotten. So in that perspective, ultimately this litigation went up to the it went up to the Court of Justice of the European Union, and the Court of Justice of European Union made the search engine responsible, that is Google, responsible for processing personal data of an individual to protect or uphold the right of eraser, so that he or she no longer be traced. So the right of eraser, we're going to get its recognitions again in the GDPR. Is one of the biggest global legislations we got on the privacy right, of the data privacy right of the European citizen. So we're going to get this issue, this matter also codified in the GDPR. So we'll discuss on that later part on. Now, so this is the case where the Court of Justice of European Union observed that the search engine, they have not given any liability or attach any liability against the media publication who publish the news. But in this case, the Court of Justice of European Union has made the search engine Google responsible for processing the personal data of an individual and uphold the right of eraser, and so that he or she no longer be traced, are being upheld by the Court of Justice of European Union. The concept of right of being forgotten has got a second seat compared to the First Amendment of USA Constitution. Karnataka High Court judgment, and there are some applications or petitions as reported. It's pending in other honorable High Court in India, and obviously we are getting the personal data protection bill is there, which is yet to be ratified to be a law, or yet to be ratified to be to an act. So if this bill been passed, then we'll get a law wherein the right to be forgotten has got legal recognitions in India. So the right to be forgotten and general, if you go by the now if you shift our attention towards the international law, then we'll come to the very famous, most prominent global law today, and that is on privacy, and that is called General Data Protection Regulations, the GDPR. And in the GDPR, the concept of right to be forgotten is there in Article 17, and in Article 17 the right to eraser, that is the right to be forgotten, is stated. And as per the Article 1, the data subject shall have the right to obtain from the controller the eraser of personal data concerning him or her without undue delay, and the controller shall have the obligation to erase personal data without undue delay. So right to be forgotten is a very important, very crucial personal right of an individual, and we are to see more and more judgments and rulings in India and abroad on this subject. So and obviously the answer lies in the hand of time to see this interesting fight going on through the law, through the technology, this interesting great conflict between the freedom of expression, the right to be forgotten, the technological issues especially for the search engine and others, and these are to be decided only by the future, and we will have to wait for the result to come. Thank you. I'll request you all to share my videos if you like my video, and obviously if you have any kind of any point, any query, anything, you can comment on my video. And thank you friends, thank you.